All rise, please. Court's not in session. Judge, in front of you, we have number 4.
Good morning, Your Honor.
Good morning, Daphne.
Good morning.
On behalf of the
First of
plaintiff.
all, let me apologize. I teach on Wednesday mornings at the UM Law School, and traffic was not pretty on the way back from this morning, so I'm sorry about the
I was
delay.
very shocked that traffic was that
Please
bad.
I
be
know,
seated,
me too.
everyone. Thank you.
It's a good thing I was seated in the car, you know. All right, what number?
Number 4, Your Honor.
All right.
We're here on 2 matters. The first is Mr. Phillips' pro se objection to the foreclosure sale. I represent the third-party purchaser.
Yes. All right.
It's Mr. Phillips' objection. Basically, I think this was an
All right.
estate.
My understanding is you were in the Marine Corps?
Yes, sir.
What position?
Infantry.
Okay. All right. All right, thank you. All right, go ahead.
Mr. Phillips' objection basically says that he's an heir of the deceased owner and he wants to buy the property. He wanted to buy the property. He is an actual party to the. Was an actual party to the foreclosure. It's a 2016 case. Obviously, I can let plaintiffs speak to the foreclosure itself, but our position is it's not an adequate objection or basis to object to the foreclosure sale itself.
Okay, well, I mean, I agree with you legally. My question to you is, and I'm going to ask the 3 of you to talk just for a second, and that is there any possibility that if I were to order everything be given back to you as a third-party purchaser, what's your position in that regard, and whether or not he should be allowed to do that, and I don't know from the bank what the bank situation is.
Judge, our position that exactly that it's not a legal basis to vacate the sale, but the sale should stand. But
The other thing, Your Honor, is that this is not a situation where you have like a relative who didn't know what was going on in the foreclosure and said, oh, if I had known this, I would have bought the property, whatever. This, Mr. Phillips is an heir. He was a party to the case. He certainly
Yeah, I
couldn't-
know, but the documents I looked at show he qualified for a $220,000 mortgage, number 1, and then number 2, this was substantially less than that.
Right, well, I will tell you.
I don't know
talked to
why
my-
he didn't do
I talked to my
anything,
client
but-
briefly, and they might be willing to work out a deal where they would possibly sell the property to this gentleman also, because that's a possibility, because he actually might get a windfall from that. I don't necessarily want the plaintiff to hear this.
Well,
but-
let's put it this way. If he gets a windfall, or you get a windfall in that circumstance.
Well,
So here's what I'm going to do. Let me just ask the 3 of you just to talk for a second out there, because let me just tell you that what you have put as grounds for objection legally is not a grounds for objection to the sale, okay? I mean, I legally can't do that, but I am going to ask that they talk with you to see if there's any possibility. If you really want, are you living in it now?
Yes, sir. I've been keeping it up since.
Then why have you not, before you filed the objection, why did you not do what you
Talk
did?
to reverse mortgage every time I call them.
No, but I got the objection, I mean, you qualified on the 11th, the sale was on the 14th.
Yeah, but see what happened when I got out here, it was too late. They had already done did the procedure.
Okay,
So
well,
I feel
all
like
right,
the sale-
let me do this. Let me let the 3 of you talk and see if there's any possibility that this could be worked out or not, okay? All right, and I'll come back to it immediately, all right?
sure, thank you.
Can I have one other, Judge? Can I have
Yes,
that heard now?
let's do that, yeah.
It's number 8. It's a motion for a writ.
All right, Kenya Perez,
It's the properties at 419 Northwest 25th Court.
all right, there's nobody present, I'm gonna
And
grant.
he's the only one checked out for that.
Okay, all right.
Thank you.
Okay.
Number 12,
Sorry.
Judge, is the court reporter on number 12.
Oh,
All right. Morning, we're here on Fannie Mae versus Lopez, 17-2085. Let me have appearances, please.
Amir Saeed for the plaintiff.
All right.
Peter Meltzer for the plaintiff.
Thank you.
E.T. Sharon here for covering for Mr. James Ackley for the defendant Rick Lopez.
Okay, apparently you've drawn a crowd because they've got two lawyers on the other side to stand up to you,
Yeah,
to attempt to
apparently.
stand
For good reason, Your Honor.
up.
So, amusing story, Your Honor. I think that you would find this very amusing.
We'll be the judge of that.
I am covering this hearing for Mr. Ackley. His paralegal, with candor to the court, apparently didn't file the notice of hearing or file the motion and just thought that e-courtesy was enough. So, I have been instructed to bring this to your knowledge and to see if we could go forward since we're all here based off of the fact that we have a trial in March and we are asking for 3 depositions that we need to take care of. The plaintiff's position is to set it so they can object to it. We'd rather.
Well, have you done anything in writing? All I saw was a notice of hearing, but I don't see
Yes.
anything in writing.
Well, actually, that's what I
When
just.
did that get filed?
That's what I'm saying, Your Honor. I don't think he filed it.
We've never seen. the
Yeah.
notice
Because I looked at
of
the court
hearing
file, there's
or the
nothing.
motion.
I don't think he filed it, and that's why I started it off with amusing story. Because it's not in front of everybody else besides me.
Well, it was amusing to you, and so. No,
I just don't wanna get yelled at.
And understandably so. So, all right. There was another one, though, that I saw, a motion for extension of time to reply to the defendant's amended affirmative defenses. Have you all talked about that or not?
No, it wasn't noticed, so I didn't. I mean, I don't have an objection to it if they want 10
Okay, I mean,
days.
I was gonna grant it until the 31st of this month,
No
which is what,
objection.
next Thursday. So,
Should be okay.
all right, so that's granted,
Would you like
plaintiff's
to
motion for
reset this?
extension
How
of
do you
time.
want to deal with the
All right,
depositions?
on the depositions, I wanna see a written motion.
So have them
I get a
file it.
copy of it, so file it. I'm not gonna hear it if if they haven't been notified and I haven't been
Understood.
notified. So,
Understood.
Okay, so.
All right, I'll have it reset. and
Reset
have
it
filed.
for either, get their agreement, if you wanna set it for next Wednesday, that's
Okay.
fine. If you wanna set it for the Wednesday after that, that's fine too.
Okay. All right.
Okay.
Thank you, Your
Number
Honor.
6,
We're gonna have 3 lawyers, though.
All right.
Morning, Your Honor.
Morning.
Well, this is supposed to be the defendant's, motion to vacate sale. Stacy.
Sorry about that.
She didn't check in with the bailiff, sorry about
Oh,
that.
I think
okay.
she checked in.
she checked in?
Yeah, I did. Come.
Come on up,
You're
please.
here.
Okay.
Alright, we represent PF Development, LLC, which was a successful third-party purchaser, at the foreclosure sale held on January 8th.
Okay.
I will let, the defendant go ahead and state her grounds as for the motion to vacate sale.
Okay, tell me your name and what happened.
My name is Anastasia Pierre. What happened is, I have the loan with Ceteros, and then while I was trying to do the loan modification with them, and when I called, they tell me they sold it to a different financial, which is Celine Finance Inc. So when I came from work, and I find a paper that says the sale gonna be for the 8th, and I say I come because I'm in process of doing the loan modification, doing the package. And when I call Celine Finance, they tell me give them at least 7 to 10 business days to upload my file because I'm new to the system. So that's why I didn't have nowhere what to do, what else to do. So, and that's when I find the paper that say, okay, here's the house went for sale.
Okay.
So, Your Honor, this sale has been canceled twice prior for the same reasons that the defendant is stating now for the loan modification application being submitted. It's been canceled twice. The third time, she did file a motion to cancel it, and it was denied, and the property did go for sale. So we would ask that the sale be allowed to stand, and that the certificate of title be allowed to issue, as we don't believe that there's any legal basis to her motion to vacate sale, as per the relevant case law.
All right, anything else you want to add?
Your Honor, my Honor, what happened is I had a lawyer. Okay, I used to pay like $1,000 every month from June until like November. So, but he used to keep me posted. So, and then the last time I spoke with him, he told me he came because I never come here because I was at work. So he told me, okay, he came, and the sale did push to the 31st. So that's why I say, okay, I have enough time to see, because they tell me the file was going to upload to Celine Finance on the 7th. So that's when they transfer everything. So I thought that I have time. So until last minute, I received the letter state, okay, the house going for sale on the 8th. But I'm just trying to save my house.
No, I understand that and I respect that. The problem is it's not once but twice. The sale has been moved and it was for you in order to be able to get and qualify yourself to get the financing
The problem
for
is
the house.
because they transferred the loan.
Well, but the last time, that's the reason why. But the prior 2 times, and it's a, the case is, year and a half old, and there was lots of time in there to do that. The other real problem is that legally, this is not a legit legal objection to the sale. So I'm going to respectfully deny your objection to the foreclosure sale, overrule it, and affirm the sale that did go through on January 8th of 2019.
Thank you. I do
Now,
have a proposed
what are we
order.
talking, have you talked
We have not
about?
obtained even a certificate of title, so written
I
possession
understand
is
that.
not even on the table right now.
Let me just advise you, all right?
Yes, sir.
That they're going to be coming to the house in the next month or so. All right? They're probably going to get a certificate of title in the next day or so. And that allows them to go ahead and take possession of the house. My request of you is, or my advice to you is, please be looking for another place to go to. Okay.
How long,
So, I mean, you can talk with them. I would ask that you talk with them about it, as I'm, after I've signed the order. But please, for your own sake, talk with them about that, okay?
I'll go outside and I'll speak to her, yeah.
Okay.
Thank you, Mayor.
Thank you.
Judge, can we please recall number 4? You part number 4?
Yeah,
Yes.
and I have 5.
Right, when you finish 4 and then 5.
All right, yes.
We had a chance to speak. One of the things that occurred to me, Your Honor, is that Mr. Phillips actually doesn't even have title to the property because the property was owned by his mother who passed away. He and his 2 sisters are heirs, so he actually couldn't even qualify for a loan to refinance or pay them off until a probate's done. And according to him, I asked him, he said there's no probate even been opened yet.
Because I thought I saw that this was against his mother and the estate of his mother. I thought that's how it was titled.
Well, right, that's probably just done for procedural purposes, but there is no actual probate open. It's the estate of and any heirs are known or unknown.
Okay.
I will represent to the court, I talked to him about, obviously I'm not in a position, I don't have authority to agree on any kind of arrangement to resell or reconvey the property to him. Actually, if my client were able to work out an arrangement to sell him the property back, he would be able to actually avoid the probate. He wouldn't have to do any probate because we would have good title
Right.
through the foreclosure. But I certainly represent to the court that, if we do get title, I will make a good faith effort to have my client try to work something out with this gentleman. We did, as far as what we bought it for, as the court knows, this gets bid on by everyone in the world. So, what we bought it for, I think, it was based upon competitive bidding. It wasn't based upon mistake or the fact that other people weren't allowed to bid. So it was good faith bidding. The sale itself was valid, and also the fact that certainly Mr. Phillips, as a party to the case, not coming into the last minute unknowing about the foreclosure, certainly could have filed motions to postpone the sale or cancel the sale or any number of types of motions to avoid the sale from actually
No,
occurring.
I agree with you.
Yeah.
Remember what I said earlier.
Yeah.
Legally, his objection is there's no
Right.
legal grounds there. But
And we will not pursue further possession at this point. We will keep everything in place so he takes possession, obviously.
all right, would you consider the possibility of this I need to leave to you all to do, but consider the possibility of if you're in ownership of the house, of leasing it to him while he attempts to.
Well, certainly. Certainly,
go through that process.
certainly.
Um,
Certainly, and I'll, no, I wouldn't, no, I'm not gonna pursue the motion for it today.
Okay.
I'll talk to my client, and I'll make sure I have his number, I will talk to my.
Because I
client.
got the impression that your client is there for, this is an investment purchase.
It is an investment, yes, yes.
I mean,
it
that's
is.
what I.
Yes, and we
That's
won't,
what it
we're not
looks
seeking
like.
possession today.
Okay.
But, you know, we would request that the objection be overruled and we obtain title.
Okay. All right, Mr. Phillips, you've heard what's gone on here in court. I know you talked outside of court. I am going to respectfully overrule your objection to the foreclosure sale. It legitimately went forward. Your objection legally is without legal ground. So, but he's indicated that he's going to attempt to work with you. So I hope that that happens. Okay? All right. Thank you all very much.
Thank you, Your Honor.
Thank you, Judge.
You're welcome.
I'll just finish filling out the
You
order.
wanna go ahead and do number
Yes.
5?
Yes.
Number 5,
Thank you. Judge, number 5 is in order to show cause, there was only one answer filed by the title owner, which basically got titled through the association sale. The note and mortgage was already filed. We tried to get the court file, but however, when I went yesterday, they told me that it was still not back, from storage, I guess, to be here, for me to bring in, but I do have a notice of filing, the originals, which were canceled out of prior foreclosure action. This is just the second action. And so there were only 2 affirmative defenses standing and amount owed. The person who filed them is a party because they're titled, but they're not a party to the note and mortgage. And we don't believe that their affirmative defenses should stop us from being able to receive judgment today. Also, they were noticed, and so far, I don't have a watch.
Well, I'm looking, I see, well, let me ask you this.
Sure, Judge.
I see David Sherman on the list of lawyers. My recollection is he's an assistant county attorney. Does the county have a, some type of a lien or not?
They said they're actually not opposing, Judge. Their answer says they do not oppose
Okay.
the order to show.
All right, so they have no lien then? Okay.
Yeah, they have no issue.
All right.
The only person who had the issue is the title owner, somebody in a second. Red Sunset Homes, who purchased through the association.
Okay. All right, let me see but you do have the original note?
They were previously filed, Judge, and the court file was not ready for me to
Okay.
bring in.
All right. Benita, what do? We put in a request for the
The
original
request
file?
was done, Judge.
No, but she's the clerk and she has more influence.
Oh.
So, it's her office, so. Okay, all right, then let me see the,
This is the
your-
notice
your
of
file.
filing of the originals, which,
yes, sir.
that's what we previously filed.
No, Q2, the Q2, I got the Q2. Thank you, sir, appreciate it. You wanna take the original?
All right,
Make copies of the original,
this is
I'll be
the
right back.
original note or a copy of the.
This is what we filed, this is a copy of what we filed, the original.
Okay,
So it's a copy of the original,
all right,
because we can't get the court file.
all right. Benita, I'm gonna go ahead and sign off on the copy of the canceled, and then when we get the original, you can bring it to Chambers and I'll take care of it. Okay, all right, we'll take care of it.
This is the file. This is it. The
What are you
45
looking
day-
for in
the
terms of the
45
sale
day
date?
sale date.
45? All right, March 11.
Thank you.
Benita.
Number
All right,
one.
thank you. All right,
Morning, Your Honor.
morning.
Andrew Broxma, on behalf of plaintiff Marbella Bay HOA Association Incorporated.
Okay.
This is a motion to reopen the case and to enforce the settlement agreement. The defendant entered into a payment plan, which had whatever terms of the settlement, if they breached
No,
payment
they
plan,
stopped paying.
they stopped paying. So, under the terms, we're entitled to a final judgment.
Okay, yeah, no, I saw it, I read it. Let me see the
Oh, so
final
let me
judgment,
approach?
please, yeah. All right, Pamela McGriff. I thought maybe she would come forward since you set this and get it taken care of, but.
It's possible. I know there may have been a resolution with the bank, but
Shoot. Tell me what the resolution of with the bank was, do you know?
well, there was a final judgment, but it was it ended up being vacated, which is why we didn't immediately enforce the settlement agreement, because the bank foreclosure would have superseded this case, but
Right.
it's been vacated. I don't know the exact reasons it was vacated. We weren't privy to that discussion, so it may have been a workout, it may have been just something the
Right.
bank said.
Do me a favor, just make sure this gets to McGriff,
It will be.
and so that, you know, if there's any possibility
It's not
it
a
gets.
surprise.
Right. Okay, all
Thank
right,
you.
thanks. All right, what else?
Number 13. Wendy?
Sorry, Judge. Which do you decide for plaintiff and defendant? Okay.
Your all's choice. All right, this is on 18-1149. Let me have appearances, please.
This is Samantha Nidus of Loan Lawyers on behalf of defendant Raul Lacuna.
Okay,
Wendy Tabb on behalf of the plaintiff, HSBC Bank.
okay, all right, so it's your motion, let me hear from you.
Correct. Your Honor, this is defendant's motion to dismiss. Plaintiff does not have standing to bring this case. And the reason is because there's a lost note, and the copy of the note attached to the complaint contains no endorsements at all. Not blank, not special, nothing. There's nothing that shows that HSBC has a right to enforce this note that was made payable to Fremont. And further, there's an assignment of mortgage, but it doesn't assign the note along with the mortgage. Therefore, under Lamb versus Nation Star, 174 Southern 3rd, 1039, it's a 4th BCA case from 2015. The mortgage follows the note, but the note does not automatically follow the mortgage. So there's no way that plaintiff can show at this time that they have any right to enforce the note. Further, if there is no blank endorsement or special endorsement on a note, they would need to convey via the assignment of mortgage, and where they can't show that, they do not have standing to foreclose, and that's under Gorel versus Bank of New York. Gorel versus Bank of New York Mellon, 165 Southern 3rd, 44, 50 CA 2015.
Okay.
Good morning, Judge. We would respectively say that these are affirmative defenses that should be raised as long as plaintiff alleges in the complaint that they are the owner and holder of the note and mortgage, that they should have a right to proceed under the four corners of the complaint. These can all be contested as affirmative defenses, and we would have to prove that later at a trial or a summary judgment.
I mean, I do agree with that. I think I'm gonna see you on a summary judgment motion as soon as some homework is done in the case, so the motion to dismiss is respectfully denied. 20 days?
Sure.
Okay.
Thank you, Judge.
All right, thank you.
Wendy, let's do number 14 now, please.
Perfect, let me grab all my files which I left over there, so.
Because you rushed us.
Yeah, I do apologize to you. Wendy's having a bad day, hard day.
It doesn't matter, whichever one you want. Judge, number 14 is
Yes.
a motion for default against the unknown tenant and Elizabeth Yenzer. They were both properly served and have not filed an answer. I believe that this is Mr. Yenzer, who is here today, who has filed an answer in the case, and that's why we are not proceeding to move for a default against him.
Okay. Is your first name Steve?
It is.
Why is that name familiar? Is there another case that's on the calendar recently or in next week or something like that?
Not that
The
I'm
name
aware of. Do you have another?
Steve Yenzer? Okay, all right. Maybe it's just because of reading this file, but, all right. What's the situation? I mean, it's not you, is it your wife?
My wife and my son got involved in it because he signed a certified delivery to the house.
Okay,
My son lives with me.
okay.
My wife, I didn't have her respond because I was responding, I thought that was adequate.
Number 13, right?
Yes.
We own the property together.
Okay.
Judge, the situation is, I don't deny the note, I don't deny the mortgage. I'm recovering from throat cancer and have not been able to work properly, so I've lost income. So I defaulted on payment to the note. And I put the house for sale. It's being held, brokers open today, and every weekend it's held open. I've lowered the price on it 4 times. I'm committed to selling the property, satisfying the mortgage, alleviating this problem. I don't want this to be creating a bigger problem, which would cost me more to try and satisfy it. That's why I responded to them and they replied to file a motion to vacate.
All right. Let me ask you this. Tell me what your position is, knowing what he has just said. I mean,
I can convey that all to the client, Your Honor. Unfortunately, when they give me a motion for default, they don't give me specifics to the file.
Okay.
I have no problem, at this point, we're not moving for summary judgment, we're not
Yeah,
moving for
yeah.
anything in the case, we're strictly moving for
all
a
right.
default against.
I'll tell you what I'm going to do. I'm going to deem his letter
Okay,
to be a response on behalf of both himself and his wife. Okay.
perfect.
And that way, so I'm going to respectfully deny.
As well as the tenant as well?
Yes, and the tenant. Was there a default that was entered?
We're moving today for a default against the unknown tenant, which is
your son. Okay.
and the wife.
All right, let's make it on behalf of everybody,
Okay,
okay? And so
perfect.
it's denied, and
Okay.
then they're gonna be back in touch with you. I hope things work out,
Thank you.
all right?
Thank you. If you just give me one moment, I'll prepare an order and I'll give you a copy of that.
Thank you. Thank you.
Yes, sir. All right, what else?
Wendy, you wanna go ahead and do the?
Sure, I just have 2 more that I don't believe anyone's here on those, Judge.
Okay,
Number 2 is our motion to reset a sale.
yes, when?
Next available, please.
Okay, March 11.
Okay, good. Okay.
Thank you, Your Honor.
Just, thank you.
All right, what's the next one?
Last one, Judge, number 9. And this is a motion, plaintiff's motion for summary final judgment. All parties have been defaulted, Your Honor.
Let me see the order and the note, please.
Yes. And the original note is on the check for the vote.
Okay.
Would that also be the same March 11th, Judge, or?
Yes. That's what you're requesting? I mean, is there a further date that you're
No.
looking at? Okay.
That's perfect. Just wanna make sure I fill in the correct one. Your Honor, and I'll prepare an order on the other case.
Okay.
as well. Thank you.
Number 10. Yes.
I'll prepare it.
That's right.
All right, and these go back, I don't know if you want those filed or they go back to. All right.
Good morning,
Yes,
Your
ma'am.
Honor.
What num-
Jennifer James, number 10.
Number 10.
On behalf of plaintiff, Artesa Community Mayor's Association. So
Yes, I've read it. Is there anybody here? Joshua Ortiz? Okay, I'm gonna grant it,
Okay, thank you.
please.
And then we request the next available, please, for the sale date.
All right, March 11th. Okay, thanks.
What's your number?
Number 7.
Number 7.
Morning, Your Honor.
All right, Mark, give me 1 second.
Judge, I believe this is a court report on number 7.
No, 11.
Yeah, but this also,
I dismissed her.
oh, you dismissed her, okay.
Okay, all right. Arthur.
Thank you, Josh.
Yep.
Okay, that's for you. I'm not used
All
to
right,
this court.
this is number.
Number 7. Defendant's motion to dismiss David Friedman from the plaintiff, Your Honor. One-page motion just denies that it's got a 22.
I'd already read it. On the merits, I was gonna deny it, not just because they're not here.
I have blank space for days. File an
I'll put in 20.
Thank you, Your Honor.
They'll be in touch. That's enough.
Okay, Arthur.
Number 11.
Arthur.
Yes.
We're gonna agree to deny it because it's moot.
Good morning, Your
And then we have a court report on number 11.
We do, Your Honor.
It
Good
got
morning,
sold
Your
at
Honor.
9 in the morning, Your Honor, and they actually have no record of the evidence that I have to support the cancellation, which is the submission of the short sale offer. But it's moot anyway, and that's okay with me.
Okay, all right.
Yes.
All right, so let me just have an order as denied as moot.
Denied is moot, okay?
That will be fine. Just for the record, it's Eddie Leal on behalf of the Plaintiff Wimbledon Funds Society. And
yeah.
Good argument, Mr. Leon.
I actually don't know how that works. Do you have a window after the property is sold to be able to undo it, or that becomes an objection to the sale at that point?
You know, when they had me become a judge and they swore me in, they wouldn't let me give legal advice
Legal
anymore.
advice,
So
yeah.
I can't tell you, but you can ask Mr. Leon.
I know once it's sold, it then becomes an objection.
outside of the record, I'll share some thoughts. Are we off the record now, Matt?
Yes.
I think that current standards right now is that you're not, it's, I think, bad practice if you're waiting the day of to cancel a hearing.
It used to be at 8:49, 8:45 in the morning.
I know, and you can go down to
do
the
it
third
that day.
floor and,
Right.
you know.
I remember
but-
that.
That's what I said. In current practice, same day is
Is a no-no?
is a no-no.
Yeah.
I mean, unless you really have to, but
Now with the rules of 7 days, I had this filed 7 days ago, but that's something
Yeah.
I think everybody's learning at this point.
So let me correct you.
Yes.
Thank you, Your Honor.
Thank you, Your Honor.
All right, great, thank you all. Thank
And
you.
we're waiting a decision on that case that.
Oh, that was up to the third?
The third, we had oral argument. It was
And so how was the oral argument? Who did the oral argument?
none of the people that appear before you. Well, I did it for my case.
Okay.
I
I didn't know whether Judge Shepard was gonna
No,
do
no,
that or
Judge
not.
Shepard and I talked about it. We actually
Okay.
had maybe 3 or 4 hours at the country club of preparation. We had a great time. I'm not sure we talked about anything about the case,
Uh-huh.
but he said, you'll be fine. And I was like, okay, as long as you give me the blessing, I'm good. So he's like, vaya con Dios. I was like, okay, done. I'll go do it. So I think I had more fun in the preparation. Well, what happened was, it unfortunately happens all the time in circuit court, which I think is a practice that courts should frown upon, but literally 3 or 4 minutes before the start of oral argument with the third DCA, the opposing side turns to me and says, oh, I'm not sure if you received it, but we just filed a notice of supplemental authority. And I'm like, what? And
What did the third do?
he referenced it in his reply, and Judge Salter was kind of looked at me and said, "Don't worry about it. We got you." And nothing else happened. But
Okay.
he referenced it. But when I actually had a chance after to read what he had put in front,
Right.
nothing really to do with the issue. I mean,
Interesting.
I think it was to throw you off or something. But nobody. I mean, they do it like 3 days before, 2 days
That's-
before.
yeah.
Not 2 minutes
That's
before the hearing.
Well, and usually a notice of supplemental authority, I mean, if you look up the case law in it, it's supposed to be for a case that came out after you filed your briefs, but before oral argument, or after oral argument and before their decision.
Exactly,
So-
exactly. And the case that was cited dealt with something that
Oh,
was.
this is the original?
Yeah.
Yes.
Okay.
On number 5, George.
Gotcha. Should I
Yes,
turn it
please.
upside down and sign this one?
Thank you, Judge.
Your Honor, I think the case was like a 2013, 2014 case. And obviously that was way before we had briefed the issues.
Right. Oh, yeah, no, it's
Because I
interesting.
understand if it's something after, I get that, I understand that, but it was something that was like years before. They could have bring it up and give an opportunity to actually.
No, I gotcha.
Yeah, yeah, that, so we're still waiting, still waiting.
All right, well, you'll get there eventually.
Yeah, eventually. Your Honor, you have, is this?
That's.
Oh, that's, okay, sorry, I was like, the court reporter might have left it.
Don't take the videographer's,
Yes, I don't want to get in trouble.
That's theft, and it'll be on tape.
Actually, you have another one here. Oh, wow, there's like everywhere.
Yeah, no, yeah.
Okay. Oh, wow.
He's very thorough.
I can see that, no matter what you say.
All right, see you later.
Bye, bye, guys, thank you. Thank you. Oh, I need that.
All right.
Benita check with cold call, there's no cold call today.
Oh, good, thank you.
Can I help you, sir?
1501?
Yes, who you here for? Which,
Judge Silver.
he said 800, sir.
Yes.
Oh, you can come up here, sorry.
I'm sorry.
No, no.
Wait. Retired Judge Silver?
Yes.
Oh, who's next to him?
Oh. Getting closer.
Oh, I thought you said Judge Zilber.
Not so.
Okay,
No.
gotcha.
Handle some of these
All right.
hearings from the judges.
If you sit there, business is over. Because they have the other judge, the retired judge in this floor.
Okay.
So,
Oh, wait a minute, that's Sam Silver?
yeah,
Oh, wow.
he's here.
Okay, good. Oh, that's great. Yes.
Curious if you share, I have oral argument with the circuit panel, Veronica Diaz and Inter Mendes. Do you have any, I've never been, I'm not a criminal defense attorney, so I've never been before them. Lisa Walsh, she'll be in the panel, I know her, she was in civil.
No, she's very bright. The other two, yeah, wait a minute, let me see. Are they?
Veronica Diaz.
I mean, I know Judge, Tinkler Mendez has a big criminal defense background.
Okay. Okay.
I don't, Judge Veronica Diaz is fairly new, so I don't know what her background is.
Okay, okay.
Okay.
Thank you.
Yep.
Good to see you.
All right. All right, Arturo,
Judge?
let's go.
Arthur, thank you. Thank you again.
Have a good day, sir. Yes, sir.
Benita, you're all set?
Yes, sir.
Okay.
Upstairs for the next event. Bye, Judge. Thank you.
All right, see you later.
Are you gonna stay here the rest of the day, or you picking up?
Let me double check, because I believe for now we're just doing the foreclosure counter.
You know that, this attorney told us, small, you know those people in the hell contempt by tomorrow, they have to pay the money. There is, he called the guy, the guy saw, I just wanna call the office, and they haven't given me the money yet. I said, sir, but the hearing is not until 1:30. Maybe within 24 hours they're coming with the money. I don't.
Is that, no, it's tomorrow afternoon.
Right, but he's already calling, you know, like, it's
okay.
buzzing the court, you know.
Okay.
I'm like, keep the time, maybe he'll, oh, no, they're not gonna come with it. I said, okay, and, you know, if they don't, at that point in time, we'll